of the Texas Department of Criminal Justice, that is prison, for a term of 14 years for each case. Is there any legal reason why sentence should not now be finally and formally pronounced, state or defense?
No.
Finding shall rise. In cause number 24, CR 300, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. In cause number 24, CR 301, all of these cases being the state of Texas versus Travante Nichols, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. And in 24 CR 302, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years. And that is another verdict signed by the jury foreperson. You may be seated. The court has received and made a part of the record the decisions and verdicts in its punishment phase made by the jury. At this time, ladies and gentlemen, the jury, your duty as jurors is completed. At the beginning of the trial, I placed each of you under a number of instructions. And at this time, I am releasing you from those instructions previously given to you. One final instruction is added. Once you are discharged, you are released from your oath of secrecy. You are free to discuss the case and your deliberations with anyone. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by me. In a few minutes, the attorneys are going to be released after we do some formalities, and they always like to speak to jurors if you were willing to wait and talk to them. They like to get feedback. It helps them with their duties as lawyers, and they always find it rewarding to be able to speak with you to see what your feedback is and input for them to make them even better attorneys. But you're also free to go home or go about your business, but they will be discharged in a little bit. And again, you are free to discuss these matters with them as you choose or not. One final point. The flag that stands here not only stands for the United States of America with the state of Texas, but also it stands for the Constitution of the United States. We, the people, that's the way it begins. In order to form a more perfect union, establish justice. That's the very first part of how the Constitution begins. And jurors who come forth for jury service are right there in the first sentence of the Constitution. Your decisions determine what justice is. And a lot of people who are selected to come forward don't show up. They find other things they have to do. Sometimes they're good reasons, sometimes it's not. But in this county, we have a very great citizens for the most part who do show up for jury service. I want to thank you for your time and your attention. You're going to get a little stipend, but it's not enough financially to reward you for your important time. But whether it's serving in public office or serving to defend our country or serving to make the Constitution work, since a trial by jury is in the Bill of Rights. Without jurors, good citizens, we are unable for this country to work. And I want to thank you for doing your service and obligations as good citizens. I hope to have the honor to work with you in the future. Until then, may God continue to bless Jefferson County and her citizens, and you are excused. Thank you very much. Ellie has documents if you need it for work or school or other purposes. Thank you. And the lawyers will be out in about 5 minutes if you wish to talk to them. And Mr. Sharp, again, thank you for your citizenship and holding. You look awfully young, sir, for your age.
Thank you.
We were born a day apart. But he's older than me by 1 day.
Yeah, it matters. That's something. Yeah, they see you, Judge.
Hold on. We still have a formality.
Yes.
All right. At this time, is there any legal reason why formal judgment should not be assessed?
No.
Defense or state?
No.
And this court is going to refer to each of these 3 cases since the parties agreed for cause numbers 24 CR 300, 301, and 302 to be tried at the same time. Each of these were second-degree felonies of aggravated assault with a deadly weapon and occurred in during the same episode with 3 different victims or complainants alleged, one in each indictment. Travante Nichols, as defendant, you came before this court and a jury, entered a plea of not guilty to each of these 3 offenses as set out in these indictments. The evidence was submitted. The jury was charged by the court after deliberating. The jury returned verdicts in each of these cases, finding you guilty of the second-degree felonies of aggravated assault with a deadly weapon. Thereafter, evidence was presented and the jury was charged for deliberations on punishment, and the jury assessed your punishment at confinement in the institutional division of the Texas Department of Criminal Justice, that is prison, for a term of 14 years for each case. Is there any legal reason why sentence should not now be finally and formally pronounced, state or defense?
No.
Finding nothing to bar pronouncement of sentence, it is the judgment of this court that you are indeed guilty in cause numbers 24 CR 300, 24 CR 301, and 24 CR 302. Each indictment charging you with the second-degree felony of aggravated assault with a deadly weapon. And you shall be punished in accordance with the jury's verdict of guilty in each of these cases. It is therefore the order of this court that you, Travante Nichols, who has been adjudged guilty of the 3 offenses in these cases.
This is the moment every courtroom has been building toward. The jury has already spoken, but now the judge transforms that verdict into a legally binding sentence. Notice one critical detail, although there are 3 separate convictions. The judge is about to explain how those prison terms will actually be served. Listen carefully, that single ruling can dramatically affect how much time the defendant spends behind.
Of the second-degree felonies of aggravated assault with a deadly weapon, and whose punishment has been assessed at 14 years imprisonment on each of these cases, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 14 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. You are here now remanded to the custody of the Sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of each of these sentences. These sentences, by law, shall run concurrently. Do you understand what has happened throughout this trial and today, sir?
Yeah.
Anything else to add by the defense
No, sir.
or the state?
No, sir.
And y'all have filled out the appeal
Yes,
formalities on behalf of the defendant?
yes.
All right. Nothing further. These proceedings are concluded and this court is in recess.
One of Jefferson County's most significant aggravated assault cases comes to a close. Travante Nichols received 3 14-year prison sentences. But because they will run concurrently, they are served at the same time rather than one after another. What do you think about the jury's decision in the final sentence? Was justice served, or should the punishment have been different?